Decoding Section 9 of Civil Procedure Code 1908. In this video, we'll understand the purpose of Section 9, the restrictions in CPC, the concept of suit of civil nature, the concept of express or implied bar. All these concepts are provided in Section 9, which is read as follows. The court shall, subject to the provisions herein contained, have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. The purpose of Section 9 is to declare the jurisdiction of civil courts. However, the jurisdictions of civil court is not absolute, and they are subject to the provisions within CPC. They are also subject to express or implied bar. Now, the provisions within CPC refers to bar within CPC, and the provisions or express or implied bars refers to bar outside CPC. Section 9 can be further explained by referring to Abdul Ghafoor versus State of Uttarakhand, wherein it was held that Section 9 provides that every court has inherent jurisdiction to try all suits, and every individual has the inherent right to get his suit tried by the court. So you can say that Section 9 not only provides for the jurisdiction of the court, but it also provides for an individual's right to file a suit of civil nature. Section 9 can be further understood by referring to Gangabai versus Vijay Kumar, wherein it was held that Section 9 makes the maxim ubi jasi remedium effective. The jurisdiction of civil court is wide, and no unnecessary restrictions can be read upon such jurisdiction. Only those restrictions can be considered which are provided within CPC or outside CPC. This brings us to the concept of presumption of jurisdiction. Whenever a case is initiated before any court, the court presumes that it has jurisdiction, and the burden of proof lies upon the party objecting such jurisdiction. So the party who is objecting such jurisdiction will have to establish that the court lacks jurisdiction. However, if the defect of jurisdiction is manifest on the face of it, then the court will not raise such a presumption, and the court will return the plaint at the inception itself.